I have stopped a hearing exactly 3 times in 40 years. Not paused, not recessed, stopped. In the middle of testimony, in the middle of a sentence, everything that was happening in the room brought to a halt and redirected towards something that could not wait. The first time was in 1989. The second time was in 2003. The third time was November 17th. I stopped it because of what I could see in the defendant's left jacket pocket. And I need you to understand something before I describe what I saw. I need you to understand who was sitting at the plaintiff's table when I saw it, who had driven 40 minutes to this courthouse, organized her documentation, sat down in that chair, and was testifying in a room that she believed was safe, because what was in his pocket was directly about her, and she did not know it was there. When I said what I said, when I gave that order, call the police now, not in a moment, now, it was because of what I understood in the 30 seconds between seeing the shape of the object in his pocket and having Officer Cho remove it. Stay with me through this entire story, because by the time I tell you what was on the piece of paper in his other pocket, his right pocket, the one I did not initially see, I think you will understand that November 17th was not just a civil harassment hearing that went dramatically wrong. It was a hearing that may have prevented something worse. I am not certain of that. I want to be careful about what I claim, but I have thought about it many times since November 17th. About the 8:15 a.m. notation beside her sister's departure time, about what that notation was for. I think about it still. Her name was Patricia Greer. She was 47 years old. She had filed a civil harassment claim against a man named Owen Marsh, who was 51, who had been her neighbor in a duplex on Callaway Street for 2 years, and who had, over the course of 18 months, conducted a campaign of harassment that had required her to involve the police on 4 separate occasions and had ultimately caused her to leave her home. I want to be specific about what that campaign had looked like because it is important. It had started small, the way these things usually start. Notes left on her door about parking, complaints filed with the landlord about noise that other neighbors had not heard, a motion sensor light installed on his side of the duplex that triggered directly into her bedroom window. Patricia had responded to each of these things carefully, in writing, attempting to resolve them through the landlord, through direct communication, through the city's noise complaint system. Owen Marsh had escalated. By month 6, he had installed a camera on his porch that was angled toward her front door. By month 9, she had found her garden disturbed on 3 occasions. Plants pulled, soil turned, nothing taken, just evidence that someone had been there who should not have been. By month 12, she had received 3 unsigned letters in her mailbox. The letters did not contain threats. They contained descriptions of her daily routine, what time she left for work, what route she walked her dog, what groceries she had purchased. She had brought the letters to the police. They had documented them. They had spoken to Owen Marsh. He had denied writing them. By month 15, Patricia had moved out. She was staying with her sister. She had lost her lease, her security deposit, and the stability of an apartment she had lived in for 3 years before he arrived. She had filed a civil harassment claim, seeking a restraining order and damages for the costs of her forced relocation. She had also filed a separate police report 2 weeks before this hearing. She had noticed in the parking area shared by the duplex that her new car, the one she had purchased after moving, parked at her sister's building across town, had been photographed. She did not know how she had been found. She was not certain it was him. She had reported it because she had learned over 18 months to report everything. Owen Marsh had denied all of it. He had an attorney, a man named Frank DeLaurie, who handled civil defense work and who had a file documenting Marsh's counterposition. Patricia was a difficult neighbor who had manufactured complaints to extract a settlement. The camera on the porch was a security measure. The letters were not from him. The garden disturbance was normal urban wildlife. He had also, Frank DeLaury had noted in his pre-hearing submission, filed his own complaint against Patricia for harassment. I had read the file carefully before the hearing. All of it, the evening before, at my desk after my clerk had gone home. I had read the 4 police reports, each one documenting the complaint, each one noting insufficient evidence for action at that time. I had read the letters, all 3 of them, which were attached as exhibits. I had read Patricia's documentation log, which she had maintained from month 2 onward, a daily record, dates and incidents, and her responses and the responses she received or did not receive. 31 pages. I had formed a clear view of what had been happening on Callaway Street. And then Owen Marsh walked into my courtroom, and I noticed something about the way he moved that I could not yet name. He arrived with Frank DeLaury at 9:55 for a 10 o'clock hearing. DeLaury entered first and went directly to the defense table. Marsh followed. He was a compact man, unremarkable in appearance, average height, medium build, dark jacket over a gray shirt. He moved efficiently, without the studied composure of someone who was nervous and managing it, and without the aggressive ease of someone like Conrad Fitch, who expected to win. He moved with a quality I noticed immediately and could not immediately name. He sat down. He placed his hands on the table. He did not look at Patricia Greer. Patricia was already seated. She had her documentation binder organized and tabbed. She was looking at the front of the room. Her posture was controlled in the specific way that people become controlled when they have been frightened for a long time and have learned that being frightened in front of the person who frightened them costs them something. I called the case. Patricia presented her claim. She was clear and organized, and she had clearly been through the documentation many times. She knew the dates, she knew the sequence, she had printed copies of everything. She walked me through 18 months in order. When she got to the letters and read excerpts from them, the specific, detailed descriptions of her routine, her routes, her purchases, her voice did not crack, but she held on to the table edge with her right hand in the way people hold on to things when they need an anchor. I watched Owen Marsh during her testimony. He was looking at the table in front of him, not at her, not at me, not at the documents being submitted, at the table, with an expression that was not remorse and not anger and not the polite attentiveness that people perform when they are trying to appear innocent. It was something more internal, more focused, the quality I had noticed when he walked in. I understood it during Patricia's testimony, during the part about her new car being photographed. He knew exactly where she was parked. He had known it before the hearing. He had known it before she filed the police report 2 weeks ago. The quality I was seeing was not nervousness or management or performance. It was attention. He was paying very close attention to Patricia Greer in a way that had nothing to do with the hearing. I noticed at this point something in his left jacket pocket. It was not large. If you were not looking at it, you would not see it. A rectangular shape, slight protrusion, the edge of something that was not a phone. Phones sit differently, have different corners, pressed against the inside of the pocket from outside, visible when he shifted in his chair. I said nothing. I continued the hearing. I asked Frank DeLaury to present the defense position. DeLaury rose. He was organized. He addressed the camera as a legitimate security measure, the letters as unverified, the garden incidents as inconclusive, Patricia's own conduct as the source of the conflict. I was listening. I was also watching the pocket. Owen Marsh had not moved. I said, "Counselor, I need to interrupt the proceeding for a moment." DeLaury stopped. I looked at my bailiff. Officer Raymond Cho had been with me for 7 years. He had been a police officer for 14 before that. He was standing at his position at the side of the room, and when I said, "I need to interrupt the proceeding," he looked at me immediately. That is when I said it. I said, "Officer Cho, I need you to come to the defense table, and I need someone to call the police now, not as a precaution, now." The room changed. Patricia Greer looked up. Frank DeLaury went very still. Owen Marsh, and this is the thing I will not forget. Owen Marsh did not move. He did not look up. He remained looking at the table with that same focused attention, as though the room had not just shifted entirely around him. Officer Cho was already moving. I said, "Mr. Marsh, I am going to ask you to stand up and place your hands flat on the table in front of you." He stood. He placed his hands on the table. I said, "Officer Cho, his left jacket pocket." What Officer Cho removed from Owen Marsh's left jacket pocket was a recording device. I want to be precise about what it was. A small, professional-grade digital audio recorder, matte black, approximately the size of a lighter, the kind that is designed to be placed in a pocket and forgotten. Based on its position and angle in the pocket, pressed against the outer edge, facing the room, it had been recording everything in my courtroom since Owen Marsh sat down. He had walked into a civil harassment hearing against him, carrying a device to record the woman who was testifying against him. I processed that for exactly 2 seconds. That was not, by itself, what made me issue the order I issued. What made me issue it was what Officer Cho found in Owen Marsh's right jacket pocket during the pat-down that followed. Owen Marsh did not resist the pat-down. He stood with his hands flat on the table, and he did not resist, which was itself information. The specific stillness of someone who has already made their calculations and is now executing whatever the next phase of them is. Officer Cho removed a folded piece of paper. He unfolded it. He looked at it. He brought it to my bench. I read it. Then I read it a second time to make sure I had understood it correctly. It was a handwritten list. Names, 5 of them. Addresses beside each name. Times beside each address. Patricia Greer was at the top. Beside her name was her sister's address. The address where she was currently living, the address she had not provided in any court filing, the address she had told no one connected with this proceeding. Beside that address was a time, 10 a.m., the time of this hearing, the time she would be in this building, away from that address. Below that was a second time, 8:15 a.m. I looked at that time for a moment. I understood it. That was the time her sister left for work. Below Patricia's entry were 4 more names and 4 more addresses and 4 more sets of times that I did not recognize. I looked at Owen Marsh. He was looking at the table. I said, "Officer Cho, please ensure that Mr. Marsh remains at this table." Patricia, and I used her first name, which I do not do in formal proceedings, because formality was not what the moment required. "Patricia, I need you to know that you are safe in this room." She was looking at me. Her hands were flat on her binder. Her face was the face of someone who has spent 18 months being afraid in ways that were difficult to explain to people who had not experienced them, and who was sitting in the moment when the thing she was afraid of becomes visible to everyone else. She said, "What was in his pocket?" I said, "I am going to explain everything. First, I need to make sure you are safe and that the right people are on their way. I need you to pause here with me." Type justice in the comments right now if you believe that Patricia Greer deserved to have someone in that room paying as much attention to her safety as Owen Marsh was paying to her location. And subscribe to this channel before I tell you what was on that list, because the other names and addresses on that paper are the reason this case became something much larger than a civil harassment hearing. The police arrived within 6 minutes. 2 officers who knew the building and knew my courtroom, and moved with the efficiency of people who had been told enough on the phone to understand the situation before they arrived. I handed them the recording device and the list. While they were reviewing the list, one of the officers made a call. He stepped to the side of the room and spoke quietly for approximately 3 minutes. When he returned, his expression had the particular quality of someone who has just connected something. He said, "Your Honor, 2 of the names on this list have active restraining orders against this individual in other jurisdictions." He said it quietly, but the courtroom was quiet enough that everyone heard. Owen Marsh was arrested on 4 separate grounds that morning: violation of court recording statutes, possession of surveilled information used in an ongoing harassment pattern, violation of 2 out-of-jurisdiction restraining orders, and a separate charge connected to the nature of the list that I will not detail further here because it is part of an ongoing investigation. Frank DeLaury stood at the defense table for a long time after his client was walked out. He was a civil attorney. He handled neighbor disputes and property claims and contract disagreements. He had been given, I suspected, a version of this client that had not included these details, and he was standing at the defense table processing what his morning had become. He looked at me. He said, "Your Honor, I had no knowledge of any of this." I said, "I believe you. You may go." He gathered his things and left. Patricia Greer had not moved from her chair. I came down from the bench. I do this rarely. The bench is where the authority is, and the authority matters, and I do not casually abandon it. But there are moments when the authority is not what the room needs, and November 17th was one of those moments. I came down, and I walked to the plaintiff's table, and I sat in the chair beside Patricia Greer, not across from her, beside her, and I spoke to her without the bench between us. I said, "The civil harassment claim is granted in full. The restraining order is issued effective immediately. The damages you requested are awarded. That is the ruling, and it is on the record, and it is permanent." She was looking at me. I said, "But I want to tell you something. That is not the ruling. I want to tell you something about what happened in this room today and why it happened." I said, "You kept a log from month 2. When most people would have decided that the incidents were too small or too hard to prove, you started writing things down, every letter, every incident, everything that felt wrong, even when you could not explain to someone else why it felt wrong. Every police report that was filed and noted and did not result in action, you filed the next one anyway. You showed up this morning with 31 pages of documentation, and you presented it clearly and completely." I said, "What I saw in his pocket this morning did not appear from nowhere. It appeared because you were in this room, because you kept every record, because you refused for 18 months to accept the suggestion that what was happening to you was not real enough to pursue. You made it visible. You kept making it visible even when the room had not yet caught up to what you were showing it." I said, "The room has caught up." Patricia Greer put both hands over her face. She sat there for a moment with her hands over her face and her shoulders very still and the courtroom completely quiet around her. When she put her hands down, something in her expression had changed. Not relief. Relief comes later, when you have had time and safety enough to believe that the thing that scared you is actually over. Something more immediate and more raw than relief. The specific physical loosening of something that has been held tight for a very long time. She said, "I thought I was going crazy. Everyone kept telling me I was imagining it." I said, "You were not imagining it. You were not going crazy. You were right. You have been right since month 2, and now the record shows it. I have thought about November 17th many times. I think about the quality I noticed when Owen Marsh walked in, that focused internal attention, and about how long it took me to name it. Not nervousness, not management, not the performed composure of someone who was worried about the hearing. The attention of someone who had come to the hearing for reasons that had nothing to do with the legal proceeding. He had been watching Patricia Greer for 18 months. He had known her routine before she moved. He had found her after she moved. He had come to a courthouse with a recording device and a list that contained her current address and the schedule of the person she was staying with. The legal proceeding was not why he was there. I think about what would have happened if Patricia had not kept the log, if she had not reported everything, if she had accepted, as people in these situations are often encouraged to accept, that the incidents were too small, too ambiguous, too difficult to prove to be worth pursuing. If she had stopped filing police reports that seemed to go nowhere, if she had not come to this courthouse on a November morning with a binder and a testimony and the decision to let the record speak, he would have left that courtroom with whatever he came with. She would never have known how close she was. I think about the other names on the list. The 2 women in other jurisdictions with active restraining orders. The investigation that followed, which is ongoing, and about which I can say only that it is active, about how many people in how many cities had filed reports that seemed like isolated incidents and had not known that the incidents were connected. Patricia Greer's binder made them connected. Her documentation, her refusal to stop reporting, her willingness to appear in a courtroom and put 18 months of fear into organized form, it pulled a thread that the police could then follow. Now I need something from you. If you know someone who is in a situation like Patricia's, who is afraid of a neighbor, a former partner, anyone, and who has been told that the incidents are too small or too ambiguous to pursue, I need you to share this video with them today. Tell them to keep the log. Tell them to report everything. Tell them that the reports that seem to go nowhere are building a record, and that the record matters, and that sometimes the record is what allows a courtroom to see what the room could not see before. And subscribe to this channel, because I am not done. 40 years of these mornings. Some of them are about money. Some of them are about contracts and deposits and documents with extra pages. And some of them are about a woman who sat in a chair in November and let a room finally see what she had been trying to show for 18 months. I am going to keep telling all of them. Leave me a comment. Tell me about a time you kept reporting something when it would have been easier to stop. Tell me what happened. I read every single one. I stopped the hearing on November 17th because of what was in his pocket and because of what was in her binder. Both things mattered. That is November 17th.